Hello and welcome. My name is Garrett Snedeker, and I'm the Deputy Director of the James Wilson Institute. On behalf of the James Wilson Institute and First Liberty Institute's Center on Religion, Culture, and Democracy, we're pleased to welcome you to our webinar today, Churches, an Existence of Their Own or Creatures of the Sovereign. First, a brief word on the two organizations sponsoring this webinar. The James Wilson Institute's mission is to restore to a new generation of lawyers, judges, and citizens the first principles of our law and the moral ground of our rights. First Liberty Institute's Center on Religion, Culture, and Democracy envisions democratic societies which affirm the essential role of religious convictions, peoples, and institutions in cultivating free and flourishing communities. We're pleased to partner with First Liberty Institute and the CRCD in another webinar, and we'll be having some more webinars in the future, but it's such a pleasure to be working with them. Some brief housekeeping items for today's webinar. We had up on the screen our logistics, so I'll just briefly point towards them again. This webinar is being recorded, and we are seeking your active participation in the webinar come Q&A time. But throughout the webinar, you're welcome to submit questions using the Q&A feature by hovering your cursor over the middle of the screen on Zoom and clicking on the icon that says Q&A. And so you'll submit questions via Q&A, and you'll be invited either to have us read your question for the panelists, or we'll invite you via audio only to ask your question to our panelists. In the meantime, you can use the chat feature on Zoom. If you have any questions, our programs manager, Daniel Osborne, will be managing the queue as well. And so now it gives me great pleasure to turn it over to the founder and director of our James Wilson Institute, Professor Hadley Arkes. Hadley.
Okay. Garrett, thanks so much for putting this together, but thanks to Adam for doing a beautiful paper, and thanks for Rob for carving out the time to come in to do this with us. Because Adam's paper really coincides so precisely with the problem and the teaching we made the center of our concerns here in the James Wilson Institute on natural law and natural rights. James Wilson, you may recall, an extended lecture, beginning, of course, with Aristotle, a lecture on human beings as social animals, that we have a natural inclination to seek company, friendship, to associate with many others in projects for ends commercial, political, religious, charitable. If the association is directed to innocent and rightful ends, it does no violence to language to say that we have a natural right to engage with others in legitimate projects. And to put it that way, we recognize that this tendency of human beings to association is not the creature of the positive law. Of course, the positive law, of course, will come in many ways to regulate those associations, most notably in getting clear that we're dealing with legitimate associations and not criminal bands. Now, Adam, in his paper, plays strongly on this point, that the right of association is not the invention of the positive law. And that point he takes as the key to unlocking a serious and quite fascinating problem. I should add, though, that the right to association, to make sense, must entail also a right to preserve the integrity of the association. And so if there's a right of people to associate in a pro-life cause or to push the ends of the pro-life movement, well, there must be some right to preserve in the leadership of these projects people who share the views and the principles that define the telos and the character of the project. Where we had that case we talked about the other day, the Martinez case 10 years ago, about the claim of the Christian group at the Hastings Law School to keep in their leadership people who are committed to the principles of a Christian society on questions like marriage. There's an old line in a side comment by John Marshall, the old Dartmouth College case, where he conceded it was quite possible that if the legislature of New Hampshire took over Dartmouth, if it displaced the trustees and took over the college as a literary and educational institution, it might indeed be improved. just as the legislature of Massachusetts years ago might have taken over Harvard or Amherst and appointed professors and trustees like Henry James, John Updike, Philip Roth. But as Marshall said, the college could be much improved, but it would not be their college anymore, not the college that those founders brought forth and whose purpose they defined. So let me fill in the bios of our two friends who've could come together. They're two accomplished men with wide-ranging interests. Adam McLeod is a professor of law at Faulkner. His interests are focused on the foundations of private law and private ordering. He teaches courses on private property, intellectual property, jurisprudence, private law. He's the author of Property and Practical Reason, Cambridge Press, 2015, which tells me he's more interested in printing the book than in selling the book. Because I too published with Cambridge. He's also the co-editor of the 4th edition of Christie and Martin's Jurisprudence. He's been a visiting fellow in the James Madison program at American Ideals and Institutions with our friend Robbie George at Princeton. But he's also been an instructor in their graduate seminar on the moral foundations of property. It's worth pointing out in this vein that he's also been a Thomas Edison Fellow in the Center for the Protection of Intellectual Property with our friends at George Mason University. In short, he's massively productive with books and articles and law reviews and other publications accessible to a wider audience. Rob Miller, our friend Rob Miller, has had a remarkable training in philosophy and law. He did his BA at Columbia in philosophy and mathematics, then he did a master's degree there in philosophy before deciding not to go on to law school. And in fact, I think the first time I encountered him is when his wife was in law school. He was on the threshold of plunging into law school. He plunged in at Yale, where he was the editor, of course, of the Law Review. He's woven quite an impressive body of work that weaves together his interest in philosophy and natural law and those moral dimensions of property and what may be called the organization of economic life. Well, he now swings between two notable academic appointments. He's a professor of law at the University of Iowa College of Law, and he's the F. Arnold Daum Fellow in Corporate Law there. But in his other academic appointment, he's been a fellow and program-affiliated scholar at the Classic Liberal Institute at the New York University of Law. And before he returned to the academy, before he returned to the academy, he was an associate at the formidable firm of Wachter, Lipton, Rosen and Counts in New York. And I'm sure that as formidable as that firm was, it found its voltage notably diminished when Rob returned to his true vocation and went back to the academy.
Wachter Lipton has seemed to have gotten along without me, surprisingly.
No essential men. I'm sure it's a diminished place. I want to point out that in our James Wilson Institute, one of our signature programs has been the senior seminar in which we bring together twice a year some gifted teachers of philosophy and law, along with some accomplished federal judges who want to get a firmer hold on the natural. And that seminar, which has been the center of our project, Rob has been truly one of the leading figures who've helped sort of light up the seminar and our whole project. So with that, let me turn over first to Adam, and Rob will come in later with a commentary. Okay, Adam, it's yours.
Thanks very much, Hadley. Thanks for the introduction. Garrett, thanks for putting this together. It's both to James Wilson Institute and the Center for Religion, Culture and Democracy. I owe a debt of gratitude. I owe two debts of gratitude to the Center for Religion, Culture and Democracy, where I'm currently serving as a research fellow, and they are supporting my research this year. My research is primarily focused on looking at private law with a specific emphasis in property and intellectual property, but as you'll hear in a minute, ranging outside my areas of expertise also, and pointing out the places where the rights and duties of private law reflect certain facts about human nature, and then drawing the connections as to what how those artifacts of law might therefore enable us to live well. I want to say how honored I am that Robert Miller agreed to serve as a respondent. I know, like many of you, I've long admired his work I ought to say at the outset that I am not a scholar of business associations. The old cliche is absolutely true in this case, that Professor Miller has forgotten way more business associations law than I have ever known. My interests are primarily about the ways in which corporate structures affect group ownership and corporate ownership. So I'm a property guy. But I know I'm going to learn a lot when I shut up and he starts talking. My approach for the next several minutes is going to be not primarily legal, though I will dip into some technical legal questions here and there for illustrative purposes, but primarily jurisprudential. And I want to start by sort of laying my priors on the table, both for examination and because I think it's actually going to be relevant to the analysis that I'm going to try to put forward. So first, I think human beings are beings made to deliberate about what is good and to choose the good freely. And so we need ordered liberty. Second, I think human beings are beings made to reflect on the fact that we do not find ultimate fulfillment within the confines of the present, but instead we transcend time. And so we can find fulfillment in relationship with the eternal source of goodness. Now, since at least the rediscovery of Justinian's Corpus Juris Civilis in the 11th century, the private rights and duties of the Western legal tradition generally have been shaped by jurists who shared those convictions. So I think it's no accident that many artifacts of our fundamental law reflect these facts about us. So viewing private law then in light of the natural law and from the perspective of religious convictions might open up insights into how the artifacts of our legal tradition have helped human beings to lead flourishing lives and can continue to do so, even when applied to new problems. I also think, as the jurists have long taught, that we are made to flourish in community, not just in that community that calls itself the state or the nation, but actually primarily in those smaller communities where we realize are more basic and comprehensive goods. Communities such as for-profit and charitable associations and corporations, schools and universities, estates of co-ownership, and the family. And I think our fundamental law reflects this fact about us as well. So in short, what we find throughout the law is particular specifications of a natural right to associate with other human beings. That's my thesis. And today I'm going to discuss two of those specifications: the right of corporate ownership and the right to divide legal and equitable ownership in a trust. Now, the right of association, I think, is natural in three related senses. First, in the sense that may be understood by students of Justinian and Grotius and Vattel and other teachers of the civilian tradition, the right to associate is fitting to human nature. So wherever the right is secured in law, and its infringement is vindicated by adequate remedies and sanctions, human beings tend to flourish. And wherever the right is infringed with impunity, we find human beings in poverty and persistent frustration. Second, in the sense recognizable to students of Thomas Aquinas and Richard Hooker and other natural law thinkers, the right to associate is natural in the sense that it is a requirement of human reason. Powerful people who infringe and suppress the right to associate act contrary to both legal and natural justice. Third, in the sense that will be understood by students of the American founding, the right to associate is pre-positive. It is not contingent upon, but instead exists independent of political power and positive law. It is not contingent upon in the sense that it is not subsequent to. We also find throughout the fundamental rights of our immemorial common law, particular instances of this right. And I think it's one of the natural rights that enables us to pursue true and substantial happiness, which of course is one of the aims of the American founding. And so when officials infringe the right to associate or fail to remedy its infringement, they undermine their own authority in the sense that they destroy some of the reasons we have to consent to their continued governance. Now, I want to begin to make the case in this favor with a story. It's a story about a group of very earnest Scottish Presbyterians who were given a very whimsical and offensive name. The Wee Frees, My last name is MacLeod, so I should have a better Scottish accent, but I don't want to, offend any of the real Scots on this call. We're part of the Free Church of Scotland, a church that was founded to disassociate itself from many of the theological innovations of the United Presbyterian Church of Scotland. When a majority of the We Free Church later decided to reunite with the United Church, the minority faction asserted ownership of the Free Church's property. This derisively called the We Frees and scorned by many of the elites, they nevertheless succeeded in persuading the House of Lords that they were the rightful owners. The Lords, of course, were unconstrained by our First Amendment and the separation of church and state, but they were content to observe that it was the We Frees who wanted to preserve the Free Church's theological distinctives, however quirky and outdated those distinctives and convictions might seem to the elites. The We Frees were in that sense, the Lords reasoned, the true Free Church of Scotland, and therefore the rightful owners of its property. Now, the judgment in favor of the We Frees precipitated an international controversy, an act of parliament, a commission inquiry, and a very messy division of the resources and assets of the Free Church of Scotland. But more important for our purposes, it precipitated and motivated a very spirited exchange amongst several eminent jurists of the day, including A.V. Dicey, Frederick Maitland, and John Neville Figgis. The question, as Figgis put it, was concerned, quote, with the nature of human life in society. So this is Figgis continuing. In other words, is the life of the society to be conceived as inherent or derived? Does the church exist by some inward living force with powers of self-development like a person? Or is she a mere aggregate, a fortuitous concourse of ecclesiastical atoms, treated it may be as one for purposes of convenience, but with no real claim to a mind or will of her own, except so far as the civil power sees good to invest her for the nonce with a fiction of unity, end quote. Now, the correspondents in this debate differed in their answers to this question, but all of them agreed that to understand the question was also to address related questions about the character of corporations and trusts. For example, the question lies at the heart of a puzzle of jurisprudence, how a company's legal capacity to own property is separate from the individuals who ultimately comprise the company's membership and ownership. It also lies at the bottom of a trustee's fiduciary duties to equitable beneficiaries, which is a puzzle because they are not reciprocal. So as Maitland puts it, the question of, quote, the personality of the organized group is tied up in the question why corporations have separate legal existence from their members, and in the question why the trust beneficiary is the spoilt child of English jurisprudence. Now, Maitland offered a very clear answer. Now, it's somewhat speculative, but of course it rested in Maitland's encyclopedic knowledge of the common law, and so it became quite influential in English jurisprudential circles early in the 20th century, though American jurists and lawyers largely ignored it. Reflecting on A.V. Dicey's earlier observations about the common law right to associate, Maitland came to the conclusion that because natural persons, that's human beings, and fictional persons, besides both of those, quote, the law knows persons of another kind. And he included amongst these the corporation, which it treats as what Maitland called a right and duty-bearing unit, like in this sense of legal agency to a human being. Fast forward now to last year when the Texas Supreme Court rendered judgment in the case, the Episcopal Diocese of Fort Worth versus the Episcopal Church. The facts are a bit complicated, but in short, the diocesan corporation holds all real and personal property of the church in trust for the benefit of its parishes, unless and until one of the parishes leaves the diocese, in which case title devolves to the diocese for its own sake. Now, a few years ago, the Episcopal Church, the National Convention, of which the diocese had been a part, attempted to assert what we might call a hostile takeover of the diocese by placing its own agents in offices of power within the diocesan corporation, and by claiming that it, the Episcopal Church, was the true beneficiary of the trust. The diocese had precipitated Tech's attempted hostile takeover when in 2007 it began to disaffiliate itself from the National Convention. Earlier, Tech had motivated that disaffiliation and many other disaffiliations around North America when it departed from essential historic doctrines of the Christian faith, such as the authority of Hebrew and Christian scriptures and the definition of the meaning of marriage. And that departure had put Tech out of fellowship with most of the worldwide provinces of the Anglican Communion. The Diocese of Fort Worth wanted to remain in communion with those majority provinces. Now, the diocese claimed ownership then both under the Diocesan Corporation and Trust and as the true church of the Anglican Communion within Greater Fort Worth. The Episcopal Church asked the Texas courts to ignore the Diocesan Corporation and Trust instruments and to defer to its own judgment that its canon law justified a takeover of the corporation and trust because the diocese had been unfaithful to the Episcopal Church. The First Amendment, of course, prohibits secular courts from predicating their judgments on theological and doctrinal inquiries. State courts are permitted to resolve church property disputes by one of two methods. They may either defer to the highest tribunal within a church or interpret neutral legal instruments of the church that determine ownership where such instruments exist. Texas follows the latter method. Declining the Episcopal Church's invitation to defer to the National Convention's interpretation of its canon law, the Texas Supreme Court followed black letter law and awarded judgment to the diocese. Now, the Fort Worth Diocese case, I think, gives us a fresh perspective on that old question of figus that the English jurists considered a century ago. In Texas, unlike in the case of the Wee Friese, the legal artifacts seem to have worked. They preserved the diocese as a body of Christians who want to remain faithful to Orthodox Christian teaching and to the authority of the broader Anglican Communion. The Episcopal Church, which stepped outside both of those authorities, was then thwarted in its attempt to transform the diocese into something other than what it was, to fundamentally alter its reasons for being. The success of the legal artifacts in the Fort Worth case and the failed arguments of the Episcopal Church, I think, can teach us something important about the ends of well-designed legal artifacts. In short, when well-formed, corporations and trusts can protect and enable the agency of associations and groups of persons and can protect them from both internal and external threats. We understand them to be well-formed when we understand them in light of the ends of those groups. I think we're also now in a better position to answer Figus's question because jurisprudential scholars have recently given us new insights, evidence, and inquiries. Specifically, we have new evidence bearing upon the old question about corporate personhood, and we have new questions that shed light upon the old evidence about the nature of trusts. Many of the earlier English jurists operated from a perspective shaped by social Darwinism, and they thought of corporate identities in organic terms. This frustrated, I think, their inquiries in all sorts of ways that we don't have time to go into. But fortunately, we don't have to consider them because in the last 20 years, analytical philosophers have given us a new way to understand the personhood and moral agency of groups and associations. The basic concept at work here comes from the philosopher Michael Bratman, and a lot of legal scholars have begun to draw on his insights. It's the idea of interlocking intentions, and I'll approach this concept with a simple example. So suppose you and I live in the same neighborhood, and suppose we're both runners. Suppose that we occasionally pass each other in the mornings before work as we're out running. But eventually we decide that we want to start running together. This requires us to coordinate, of course. We must agree when and where to meet, how often to run, how far to run, at what pace, and so forth. Now we derive all sorts of benefits from this cooperative venture. We motivate and challenge each other. We learn from each other. We can form a friendship around our mutual love of running. Eventually, other people may join us. And at some point, the group develops a life of its own, such that if any one of us fails to show up some morning, the group, which is now identifiable as a group and not a mere aggregate of its individual members, continues to exist and to meet for the purpose of running. What's happened? Well, when we happened to pass each other in the neighborhood by happenstance, we had similar intentions, but they were parallel to each other. Now that the group is formed, our intentions are shared and mutually dependent. I show up to run in part because I know that you're going to show up to run, and I would be letting you down if I don't show up ready to run. And this mutuality and sharing of plans has transformed both of us in an important way. It has shaped our motivations, our planning, and our reasons and our commitments. And as the group scales up, the group itself takes on the agency for shaping those internal parts of our identity. Now scale this example up again for more complicated associations, such as family businesses, charitable organizations, and religious associations. At some point in the lives of those associations, the interlocking and mutually dependent intentions of their various members become a sum that is greater than the total of the parts. The association develops standing plans and intentions that are independent of the particular motivations and intentions of its members, perhaps even the founding members. Anyone who's ever started a new group or entity, only later to discover that the group has a mind of its own, can relate to this reality. The new moral agent that is constituted by the interlocking intentions of the members is capable of bearing legal obligations because it is capable of acting for reasons, the reasons of the group, and therefore of having rights and duties. This is the sense and intelligibility of Maitland's reference to corporate persons as right and duty-bearing units. The unit exists quite apart from any formal legal status that the sovereign may confer upon it as a matter of positive law or formal judgment. Now, turning to trusts. We now have new questions that bring order and clarity to old evidence. In the last couple of decades, property theorists have become increasingly interested in the question whether use, alienability, or the right to exclude is the core or essence of property. We recognize that use may be viewed as more essential or important from one perspective, call it the internal point of view, while the right to exclude may be perceived as the most important thing about property from a different perspective, call it the external point of view, and the right of alienability to sell and to give might be the most important thing about property from yet a third perspective, call it the economic point of view. And with this framework of different perspectives on property, we can now begin to understand why Maitland was so interested in the common law concept of use. He was interested in the interior life of the group or the association that exercises property ownership together, cooperatively, for a common good that is not reducible to the individual preferences of its members. His focus on use was secondary to his focus on the internal point of view of the group that exercises dominion within property ownership. And from that perspective, use is the most important thing about property. Maitland taught us that use in the common law has a much more expansive meaning than it does in the civil law tradition. The common law term use, he tells us, is derived from the law French term ois, and that in turn is derived not from the Roman term usus, but rather from the Latin word opus, for work. And a student of the common law jurisprudence will immediately recognize the significance of this insight. For common law jurists, such as Hale and Blackstone and others, the core and origin of property is not self-ownership in a state of nature, but rather it is God's delegation of dominion to Adam and Eve and their children in equal shares. As the jurists make clear, the office of dominion is an office of stewardship, which certainly has lots of benefits, but is primarily concerned about responsibility to labor on earth and to order it well. From this perspective, use as work is the most essential aspect of property. And here's the solution to Maitland's puzzle. Why is it that beneficial use is the spoiled child of English jurisprudence, while exclusion and alienability are treated as derivative and secondary? The answer is that beneficial use is the whole purpose of having private property institutions. It's difficult to see this when use, exclusion, and alienability are all wrapped up in the fee simple absolute, the comprehensive estate of property. But it becomes easier to see it when they are separated by a trust. So who uses the trust, who uses the property held in trust, for what ends they use it, determines the character of the trust. The powers of the trustee are derived from the fiduciary duties of the trustee to enable and protect the beneficial use. The office of trustee is entirely derivative from and contingent upon that beneficial use. Remember another lesson that Maitland taught us. Clever lawyers developed the trust in the 14th century to overcome the injustices of primogeniture, which mandated that the entire res descended to the eldest son, and thus prevented an owner from providing for his other children and for potential charitable beneficiaries of his generosity. The trustee's duty to deliver use to the settler's intended beneficiaries was enforceable not in law, but in chancery, an institution of equity and natural justice, as a matter of conscience, even though title and exclusion must pass as a matter of law to the eldest son. The central concern of the owner-settler, the purpose to satisfy the requirement of equity and natural justice that the arbitrary rules of law frustrated, was to ensure that use was passed to those who could benefit from it and who could work to make their use beneficial for others. So a trustee who asserts the power to determine use is thus breaking faith with the purpose of the trust and of trusts generally, and acting contrary to what conscience requires. When the Episcopal Church claimed to be the true beneficiary of the property held in trust by the Diocese of Fort Worth for the benefit of its parishes, it introduced into its argument then a contradiction. It's not difficult to see how Tech's assertion of priority is contrary both to its fiduciary duties as bishops and to the purposes for which the trust exists. The Son of Man came not to be served, but to serve, and he commands his apostles to act likewise. To fail to steward the good ends for which the diocese holds bare legal title, indeed to act contrary to those ends, is to abdicate the authority entrusted to the diocese and the church's bishops. The Diocese of Fort Worth, in other words, is a real moral and legal agent whose existence and personhood does not depend upon the positive laws of Texas, nor the judgments of the Episcopal bishops about the meaning of their canon law. In this case, the positive laws of Texas declared and secured the ancient artifacts of corporate and trust ownership. The lawyers of the diocese had done their job well, and the artifacts served their proper ends. Now, lawyers and officials can and should be mindful of the ends of corporate and trust ownership, I think, even when they have legal and constitutional duties not to inquire too closely into the purposes or beliefs of particular group owners. We now have fresh reasons to affirm Maitland's speculations about corporations and trusts. The corporate form wraps itself around and approximates the boundaries of an existing organized group that has moral and legal agency. And trusts exist to secure the beneficial use of persons, including group persons. When natural persons organize standing groups around common ends, they form right and duty bearing units. And in the words of Maitland, quote, "If the lawgiver will not openly treat them as such, he will misrepresent, or as the French say, he will denature the facts. In other words, he will make a mess and call it law." Thanks.
Neat. Done. Well, thanks so much. Thanks so much, Adam. And now we'll invite Rob to come on in on this.
So let me begin by thanking Hadley and Garrett for inviting me here to speak. And let me very much thank even more Adam for giving me 2 or 3 days thinking about some really hard and interesting questions, which are, quite frankly, much more engaging than the things I usually do, like worry about corporate indentures or, whether earn-out provisions are well drafted in a merger agreement. Hadley's introduction to me was incredibly generous and actually somewhat disingenuous because I'm just a deal guy. I was an M&A lawyer and I managed to stumble into an academic career. And you're about to see that unlike Adam, I'm somewhat resistant to theory and try to be a little more pragmatic and maybe a little more down in the weeds lawyerly than most law professors are. Certainly much more than my friend Hadley is.
Right. That I know.
I will say, though, I do share Hadley and Adam's basic moral commitments. I'm an Aristotelian Thomist in morals. I believe in the natural law. I believe in a natural right of people to associate for any moral purpose. The difference between me and at least Hadley, and maybe lesser, but to some extent Adam, is that I tend to see that a much wider space between the basic principles of the natural law and what actually happens in practice. In that space, all kinds of considerations like transactions costs and institutional competence and other things tend to get in the way that make the path from moral principles to final conclusions circuitous at best. And you're about to see some of that, I think, in what I have to say here. So reading Adam's paper, I think there are really two big theses. The first one, I think, is the metaphysical thesis. And that idea is that when a group of people get together, whether Adam and his buddy running, or people forming a church, or people getting together to form a chess club or a business enterprise, when a group of people get together and have the right kinds of shared intentions among themselves, then the group itself is, in a non-trivial sense, a real person that has moral agency, right, and that can act, and that has rights and duties and so on, and is a moral agent over and above the individual human beings who comprise it. And I think that this thesis is important for Adam because it leads to a second thesis, which I'm going to call the moral thesis. And Adam just mentioned some of this as he was finishing up his remarks. And the moral thesis goes something like this. Once one of these moral persons, who are not human beings, but group persons, once one of these things exists, well, then the state has to treat it in certain ways, because if it didn't, it would be violating that thing's natural rights. Just like human beings have natural rights, and the state may not treat them just any way it pleases. In some cases, what it was doing would be morally wrong. So too, if there are these group persons, these entities that have moral agency, if the state doesn't treat them in accordance with their natural teloses, then it would treat them unjustly. And the alternative to this view, I think, that sort of comes out in the paper is that if you don't think that the groups are real entities, real persons actually there before any action by the positive law, well, then the alternative would be that corporations, or I guess limited liability companies, or LPs, or whatever type of legal entities you want, being pure creatures of the positive law, well, then the law could treat them any way they like. If the law creates, the law may destroy. If the law creates it one way, it can create it another way. And the law could end up doing whatever it pleased to these entities, because they would have no natural rights, since they're not natural things at all, but mere creatures of the state. So the structure of the paper, as I see it, has this metaphysical thesis that grounds the moral thesis, the moral conclusion. And the motivation here, the whole motivation here, is that without the moral thesis, you're left with this view that corporations are the creatures of the state, and the state may treat them as it pleases. Here's what I'm going to argue. I'm going to argue that the metaphysical thesis is not true. There are no things of this kind. Once that's the case, since the metaphysical thesis isn't true, it can't ground the moral thesis anymore. Nevertheless, the moral thesis has a certain truth to it, in that nevertheless, even though there are no real things beyond the positive law called corporations or groups with moral agency, even though there are no such real things in the world, nevertheless, the state would be acting immorally if it were to do certain things in relation to corporations or other incorporated entity groups. So why do I think the metaphysical thesis is false? Well, let's start with something simple. The mere fact that we have a noun, corporation, doesn't mean that there's a real thing in the world behind it. And Aquinas, in his great metaphysical work, De Ente and Essentiâ, which I spent many years translating years ago, he says that entities are of two kinds. There are the real things in the world, which for him fall into the 10 categories of Aristotle, substance and the 9 types of accidents. And then there are what he calls beings of reason, entia rationis. Anything that is a noun can be an entia and ens rationis, even though it's not a real thing in the world. His stock example is to say that blindness is in the eye. Blindness is not a thing, okay? It's not like a plank in your eye. To say blindness is in the eye is to say the eye doesn't function properly and it can't see. Blindness is not an extra thing in the world. There's a noun and it's a way of speaking, but there's not a thing behind the noun that's out there to be discovered. So it turns out, I think, that human beings are great at reification. We are great at talking about things as if they were really there when they're not, because doing so is incredibly convenient for a huge number of purposes. So, for example, let's say I introduce you to my friends, a married couple who I'm going to call husband and wife. Clearly, there are two real things here, the man and the woman, and they're in a certain kind of relationship together. There's not a third thing here called the couple. When I introduce you to two people, it's only those two you meet. It might make sense to talk about the couple. How many couples are you inviting to your dinner party? Is that couple getting along well? Is their marriage in trouble? It's very useful to talk about the couple, but all there really is are two human beings with a certain kind of relationship between them. Similarly, in a certain school, there might be 90 eighth graders. And for various purposes, we divide them into 3 classes. One taught by Miss Smith, and one taught by Miss Jones, and one taught by Miss Robinson. But those 3 classes aren't 3 extra things in the world. What there are 90 human beings and students and 3 teachers who are organized in a certain way, who have certain relationships obtaining among them. So, for example, it is true that if X is in the same class as Y and Y is in the same class as Z, then X is in the same class as Z. There are all kinds of relationships that obtain among them, but the classes aren't 3 extra things in the world.
Right.
To belabor the example, since it's kind of important, think about trains, right? We might say, how many trains run on the Long Island Railroad? Was the 450 from Paddington late today? Okay. Did you catch the train? But trains aren't extra things in the world beyond railroad cars that are hooked together in a certain way. It's really convenient to talk about trains, but there's no metaphysical reality to the train beyond the fact that there are certain rail cars in a certain relationship to each other. I think the same thing is true about corporations, meaning a corporation exists when there are a certain number of human beings who have certain relationships obtaining among them. The human beings and their relationships are the only real reality to the corporation. When you say, for example, that the corporation owns certain property, you could reduce this sentence in an extremely complicated way to saying that the individual human beings who are the shareholders have a certain kind of interest in certain pieces of property, the ones we say that are owned by the corporation. Their interest would be junior to an interest of all creditors of the corporation. Their control of the property would be quite small because it would be vested in certain individuals who are called the directors. Right? But you could replace all talk about the corporation owning the property with talk about a certain type of interest in property. And as my friend Adam knows, there are all kinds of complicated interests in properties, leaseholds, future interests, reverters, and so on. You could create a corporate interest in property that would give you exactly the same type of interest in property that shareholders get under corporate law. Now, philosophers love, at least modern analytic philosophers, love to do things like this. They will come along and they will give you so-called reductionist accounts of certain types of entities. They will show you how all talk about trains can be replaced with talk about individual train cars, this passenger car, that locomotive, and relationships between them. And if all the talk about trains can be cashed out in talk that doesn't talk about trains, but only talks about train cars and the relationships between them, then we say the trains aren't really real things. They can be reduced to a simpler set of objects that clearly do exist, train cars and the relations among train cars. I would say that corporations can be reduced out of existence by talk about human beings and the relationships among them. They are very complicated types of relationships. Spelling them out would be extremely laborious. This is precisely why we reify the corporation and introduce a noun and talk about it that way, because it's incredibly easier. That's why we do it. But in principle, we could, if we wanted, eliminate all that talk in favor of talks about human beings and the relationships between them. Michael Bratman, whom Adam talks about. I'm sorry, with great respect, I don't think you're reading Bratman correctly. Bratman, I think, has a view very much like my own, which is that a group is a group, an organized group, the running club, whatever you like, is a bunch of human beings with certain very special kinds of interrelationships between them, about certain types of intentions, about certain knowledge of each other's intentions, and so on. He expressly says that his account is reductionist. There are philosophers who take the opposite view. Phil Pettit, for example, or Carol Rovain, do think that groups have minds of their own, so that the group could really have, a thought or intention quite different from the thought and intention in every other human being's mind all at the same time. There are people who take that view. They're a pretty small minority, I think, in philosophy, because it's a very difficult view to defend. Right? If you want to put it in the most dramatic terms, think of it like this. Human beings are not God. We cannot call into existence additional persons merely because we agree to do it. God can will into existence a person, an immaterial person, an angel, because he's God and can create ex nihilo. We can't go about creating extra persons just by agreeing to do it. Right? What we have done is put ourselves into a certain relationship by agreeing to do certain things or sharing certain goals or something like that. But all that's really there are the human beings and the relationships between us. Okay. Let's say I've at least made some headway with you on this proposition. How do we get corporations? And here I would point out that we're not talking just about corporations. We're talking about all types of legal entities. We're talking about limited liability companies. We're talking about limited liability partnerships. We're talking about GmbHs under German law. We're talking about a société anonyme, I'm not very good at French, under French law. I once did a deal with a party on the other side, was a Dutch entity called the Beschlatten Vennootschap. Seriously. And when the party on the other side asked me what a Beschlatten Vennootschap was, I said, I don't know, go hire Dutch counsel, they'll tell you, okay? So there are all these different kinds of legal entities floating around in the world created by different sovereigns under their statutes. How does that happen? Here's what I would say. The common law provides human beings with certain ways of organizing their activity, ways of creating estates and property, for example, fees, leaseholds, future interests, ways of governing our relationships with contracts and so on. And these rules that come out of the common law are incredibly useful for lots of purposes. They respect natural law in all different kinds of ways. And for certain types of human projects, particularly where you have one individual meeting and dealing with another, they're great. But for certain shared forms of human activity, especially ones that involve a large number of persons, these rules aren't so good. So in particular, or to talk about the area I know best, there are certain types of business ventures that require huge amounts of money to get off the ground. Think building a railroad from nothing, okay? You need tremendous amounts of capital to do that. As a practical matter, you don't get that much capital except by raising it from a large number of people. Therefore, we need a large number of people all involved in this business. And guess what? It turns out that while a lot of people are willing to invest some money, most of them don't want to be actively involved in the business because they got other things to do. They might be invested in hundreds of companies. They just don't have the time, the expertise to do these sorts of things. And they know that most of their co-investors don't have the time or the expertise to do these things. They want to be passive investors. So they need to agree with all their co-investors that that's what they're going to do. And they need to appoint certain people, the board of directors, to actually manage the business. And then the board needs to hire individuals who are going to actually do the stuff on a day-to-day basis and so on. Can you do all that under the rules of the common law? The answer is mostly yes, you could, by writing incredibly complex contracts. Now, as a practical matter, it doesn't work because you're never going to get thousands of people to all sign on to a contract. But if you could overcome that problem, almost everything you get out of corporate law could be done by contract, except for one really important thing, which is the limited liability of the company. Limited liability means that when the corporation commits a tort against somebody, the tortfeasor is allowed to recover from the corporation's assets, but not the shareholders' other assets. This can't be done by contract because you can't negotiate with your tort victims until you know who they are. And you don't know who they are until you've injured them. And once you've injured them, the last thing they're going to do is give up part of their claim just because you're asking them to do it. So if you really want the rules that work for a corporate form, you need a sovereign to get involved, to come out and say, we are limiting the tort remedies of everybody against the corporation, whether they like it or not. That can't be done by contract. That can only be done by whatever legal authority has authority to change tort law. Okay. So once it becomes clear that this alternative set of rules, the corporate rules, not the common law rules, would really help us organize certain very large-scale human activities, then what happens is this: the legislature passes an enabling statute. And it says any group of people who want a corporation may have one. What they have to do is come in, file a form, provide some basic information like the name of the company and stuff like that, pay a very, very modest fee, and then we will recognize them as being a corporation. And then among them and everybody else, the corporate rules will apply. Within the corporation, that is to say, among those of us organizing the corporation, the insiders, any decent corporate law statute will basically let us have whatever rules inside the corporation we ourselves want. Now, the Delaware General Corporation Law, which I spend a great deal of my time thinking about, provides a great set of rules for groups of people who want to organize a public company. But even under the DGCL, most rules, not quite all, can be changed by agreement among the shareholders. Under the most beautiful statute ever written, the Delaware Limited Liability Company Act, however, anything goes among the insiders. If you read the DELLC Act, it basically says in section after section, it shall be like this, unless the members of the company agree otherwise, in which case it shall be as they agree. And they can have anything they want for themselves and limited liability against the rest of the world. So once the state passes enabling acts like this, anybody who wants a corporation can get one at very low cost and very minor hurdles. Consider it in comparison to the statute about wills, last wills and testaments. I think, right, that you have a natural right to will your property to whoever you want. Right? I think it would be contrary to the natural law if the state said, when you die, it's all ours. It all belongs to the state. People can disagree with me about that. Doesn't really matter. I also think it'd be contrary to the natural law if the state said, when you die, we're going to divide your money equally among your children. Your wife gets zip, your kids all get equal shares. Right? I think whoever owns the property should be able to decide for himself. The state passes a statute saying that if you want a will, you can have one, right? Just write it down, sign it, date it, and make sure you get 2 witnesses. Follow these very simple formalities, and we will respect what you write down. Right? And it would be unjust of the state to ignore that once it goes in and provides the ability for people to make wills. It would be unjust to the dead guy, and it would be unjust to the legatees. But notice this. Even though you have a natural right to dispose of your property as you want when you are dead, if you go around for 40 years saying, I want all my property on my death to go to my nephew Ralph, because I love Ralph. And you know what? This is a perfectly reasonable thing for you to do because Ralph's a good guy. It's been wonderful to you. And you say it over and over again. You say it on national television. No one doubts that is, in fact, your intention in your heart of hearts. But you never write it down. You never write it down, sign it, date it, and get it signed, attested by witnesses. What happens when you die? Ralph gets zipped. The intestacy statute applies, and it goes to your good-for-nothing son, Roland. Okay, you're only there. Now, is this unjust? No, it's not, right? Even though you have a natural right to dispose of your property, once the state comes in and gives you a way to do it, a fair and reasonable way to do it, if you don't avail yourself of it, that's your fault, okay? And the same thing is true about corporations. If you want the benefit of the corporate form, well, go into Delaware and file the bloody form. Write down what you want in your charter. Even better, file the form under the LLC Act and write what you want into your LLC agreement. And by God, the Delaware Court of Chancery will enforce it in accordance with its terms. And you and your co-venturers will get exactly what you want. Now, just because these entities are created by the state doesn't mean the state can do as it damn pleases with them. If the state were to come along and start taking the corporate property, appropriating it to itself, right? Since the corporation is really only a bunch of human beings in certain relationships to each other, the state would be treating unjustly those human beings. It would be taking away this indirect interest they have in what we call the corporation's property. If tomorrow the Biden administration decided to just drain $10 billion in cash out of Apple Inc.'s bank account, the Apple shareholders collectively would lose $10 billion worth of value. And the market cap of Apple would instantaneously drop $10 billion. That would be a real harm to real human beings, and it would be unjust. So just because the form is created by the state doesn't mean the state can do as it pleases with it, because it's real human beings who are organized under that form, who have real rights and so on. Right? Take an extreme case. Corporations, on the most extreme view of their reality, undoubtedly do not have race. They're not white or black or Asian or Native American, okay? But imagine a certain state said this: we will not give out any public contracts to corporations where more than 50% of the shares are owned by Black people or Asian people, or take your pick, okay? That would be deeply unjust. It would be a form of racial discrimination. Not technically against the corporation. The corporation doesn't have any race to be discriminated against on the basis of race. But it would harm the real individuals behind the corporation, and it would harm them precisely in a racial way, and it would be a racial discrimination. It would also be clearly illegal under the 14th Amendment. Okay? So just because the state creates the entity, it doesn't follow that it can do as it pleases with the entity. Regarding the internal affairs of the corporation, that is, and is referred to as, at least by the Delaware courts, as a contract among the internal players in the corporation. If the state doesn't respect their agreement among themselves, who gets to be a director, how long the terms are, who gets to vote, how they get to vote, and all that internal stuff, if the state doesn't respect that part of the corporation, it is disregarding a contract among human beings. That is as unjust to them as the state going into a contract for a sale of a car and saying to saying to the parties, I know you agreed to buy and sell this Toyota for $30,000, but we think the price should be $28,000. So we're just going to rewrite your contract for you and move $2,000 back to the buyer and out of the seller's pocket. Okay? Just like that would be unjust to those human beings, so too would it be unjust to the human beings who comprise the corporation if the state did not respect their contract among themselves as to how the corporation should be organized. What else? A few other thoughts about corporations and their purposes. A lot of Adam's paper has to do with the idea that the groups share an intention. And that's what brings about the nature of the group, whether we regard it as a person or just as a group of people that have to be respected. It's the shared intention that does a lot of work here. I think that's probably a very accurate way of describing a lot of small groups of people who get together to do things. The runners, the chess club, at least certain churches, and so on. It is not how business corporations work. Okay? If you look at business corporations, do not have purposes in this way. If you look at section 102A3 of the Delaware General Corporation Law, that section provides that a corporate charter shall state the purposes for which the corporation is formed. But then it says, it shall be sufficient to say that the corporation is formed for any legal purpose for which corporations may be organized under the Delaware General Corporation Law. And if you look at the charters of any well-advised public company, and I did this, by the way, for Facebook, Tesla, Boeing, Goldman Sachs, and Disney, they all say the corporation is organized to engage in any lawful activity for which corporations may be organized under the Delaware General Corporation Law. There's no real sense in which public companies have a purpose, nothing within a light year of like the purposes of churches or small organizations. Moreover, right, you do not become a member of the corporation Goldman Sachs, that's to say a shareholder, right, by having any purpose in mind. You become a shareholder of Goldman Sachs by buying the shares. And that's all it takes. And when you buy the shares, you may do it for any number of purposes. You can buy a public company shares because you want to invest in the company and you think they're a good investment. You might buy the shares because you are interested in doing a hostile takeover of the company. You may buy the shares because you want standing in a lawsuit to sue the company. Maybe you buy the shares because you're an activist investor and you really want to change the nature and purpose of the corporation. Just today, Jana Partners, an activist investor, announced it bought a lot of shares in Macy's because it wants Macy's to spin off its online business, which would be a major change at Macy's. Right? So there are all kinds of reasons why you might buy shares, and they have nothing to do with anything like a real purpose. Moreover, if you're like me, you are actually the shareholder of all kinds of corporations that you don't know a bloody thing about. I'm invested in index funds, and I'm probably a shareholder of at least 2,000 corporations, the vast majority of which I've never even heard of, right? Much less could be said to share any purpose with them, okay? So this picture works really good, this intention picture, really good for small groups like churches, maybe. Doesn't work for larger groups, I don't think. And even with churches, I would say, I would call to your attention on something one of my colleagues, Chaim Simon, a guy at Villanova, great scholar, you know what I mean? Chaim once said to me, he said, Chaim is Jewish, even trained as a rabbi. He said, you know, you Christians, you think belief is so important, all right? You know, who's a Catholic, who's not a Catholic? It has to do with, you know, you believe the right dogmas and they're heretics and so on. He said, it's very different in Judaism. You don't ask what the guy believes. You ask, does he keep the Sabbath? Does he keep kosher? Does he engage in the right practices? That's who we see, you know, who falls into groups and so on. Now, this is what Chaim told me. I don't know if it's really true. I would suspect it is. He's a pretty smart guy. But in any event, right, there are going to be some groups where it's not really belief, it's practice that would really matter. I guess one or two final words on the Fort Worth case. I love this case. This is a great case, but I think I agree very much with what you said at the end here. What happened in this case is that the Diocese of Fort Worth was a Texas unincorporated, not-for-profit association. Texas has a statute called the Texas Unincorporated Not-for-Profit Association Act. Okay? And if you do certain things, you form one of these unincorporated entities in Texas, and you get a charter, and by God, the Texas courts are going to enforce that charter in accordance with its terms. And the charter here said majority rule, but the court is very clear. It could have said majority, schminority. We don't care about that. The rule is whatever the Episcopal Church down at headquarters says goes, okay? And if they didn't like that, they could have said whatever the Archbishop of Canterbury says goes, okay? And they just got whatever they signed up for. I think that's a great rule, all right? Sometimes it'll work out right in a larger sense. Sometimes it'll work out wrong. But religious people should get the deal they signed up for just like everybody else. If that's not the deal they wanted, they could have gotten any deal they did want just by writing it down. You can see how upset Hadley is by all this at this point. So I think the way this case was decided is exactly the way to go. It might have worked out right in a larger sense here. It could have worked out wrong in a larger sense here. But from a legal point of view, this is the way to do things. Just like religious people have to make wills under the will statute, and just like they rent property under the landlord-tenant law, they should get the corporate law they sign up for and say they want. And if they want something else, it's really easy to get it in corporate law. Just hire a good transactional lawyer who'll draft you the charter you want. Okay, I'm done.
I'm not suffering. I love the paper. I love the comments. I think we ought to do this as a part of the senior project. I have questions for both, but I just want to pose this concern. We know there's only one kind of creature who's able to make a contract, to make a promise, bear a commitment, and be obliged to respect that commitment even when it runs counter to his interests. Only one kind of creature is able to do that. So as soon as we speak in those terms, we're talking about the nature of a human being. It seems to me, Rob, that in so many places, your presentation is just pervaded by assumptions of natural law, which of course is fully in there. And I'm wondering, I'll post this, we'll get back to it later. Is the one thing irreducible in this construction, that individual person you mentioned? That individual person could make a contract, or is that person too? Could we alter the definition of that person through the positive law? Or I was taking you to say, no, there is something irreducible that cannot be altered by the positive law. But anyway, let me post that one. And I have lots of questions, but let's, two gorgeous papers, good commentaries. Let me put it back now, Adam, get Adam's reaction first. Okay.
Great. Well, I'll keep it brief because I want to hear some of the questions, but as expected, Robert's commentary was extremely formidable and entertaining, and this is consistent with my prior experiences with him. I'll just hit on a couple of points of particular, I don't know, disagreement maybe, but maybe some helpful clarity. So yeah, the first thing I'd say is we're definitely reading Michael Bratman differently. So I don't think it's possible to understand Bratman's theory of standing plans and enmeshed subplans unless those plans have an existence of their own that's independent of the intentions of the individual members, such that I could join the group and then I can leave the group and the group still has an existence whether or not I share in those plans. Now, I agree with you that he wants to avoid subsuming the identity of the individual members within the group. And so I think Bratman's theory gives us an account of dual agency. The group has an agency and the individual agencies of its individual members are preserved for all purposes that are not destructive of the ends of the group. And I think this is the way to understand several of your critiques. One is, the example you gave of racial discrimination against a majority minority owned business. You obviously the corporation has no race, the individual members do, but it would still be racial discrimination against a majority owned business. That's just to say that the individual members of the corporation retain their own rights and their own reasons for action when they join the group. That's all I'll say about that. But, you might have a response. The Delaware Act, yeah. So I think it's the case that rights are often defeasible, which is to say there are absolute rights which correlate with absolute duties of abstention. In the tradition, we call them moral absolutes, right? Don't kill, don't defame, don't rape, and so forth. But most rights in our legal tradition are really not rights in that strong central sense. They're defeasible presumptions which can be overcome. So the fact that the Delaware Act begins each provision with, it shall be this way, unless you agree otherwise, is just another way to say, in the absence of agreement, this shall be the rights and duties of the parties. And I think this is also what we witness going on in the example, the excellent example of the statute of wills. The statute of wills is recognizing a pre-existing right. I agree with you. I think there's a natural right. I think this is what was wrong with primogeniture. But there's a separate practical question when you go to court, whether that natural right imposes any particular duty on the judge. And I think I agree, for pragmatic reasons, it makes perfect sense to impose formal limitations on the exercise of the right. I'll just say one more thing about shared intentions working better for smaller groups than for larger groups. I think I would draw the distinction a little bit differently. So in the case of corporations, I think I would draw the distinction between closed corporations and publicly traded corporations. So it seems plausible to me that a family business is in fact organized around shared purposes, such that the identity of the family business is constituted by the fact that we make widgets and not gadgets. And if the business were to start making gadgets instead of widgets, it would be a different thing than what the family has always done together. That seems to me a very, very different intention and motivation than the person who buys shares in a publicly traded corporation. It's something like the difference between a common good that is basic and a common good that is merely instrumental. In the first case, we're organized around something which is really core and essential to our identity as a group. In the second instance, what I want to get out of owning shares in Goldman Sachs is just a good return on my financial investment.
So let me respond to the first point a bit. So one way of thinking about reductionism is this. If the facts about where the train cars are and what the relations are among them, which one's connected to which, all that kind of stuff. If once I specify all of that, the truth values of every sentence about trains is settled, then the trains are reducible to the train cars. I think the same is true about corporations. I don't think it makes any sense to say the corporation intends to do this, or the corporation wants to do that, or anything like that, if there's no human being in the whole world who has that intention. I think the facts about what take all the human beings you like, the shareholders, the directors, the officers, of everyone. Once we know who they are and what their mental states are, their intentions, their knowledge, whatever, that's all there. That will settle, not in any necessarily direct way, but it will settle the truth value of every sentence about what the corporation intends. Whether who's getting Michael Bratman right doesn't really matter too much. We could argue about that offline, right?
Yeah.
But I mean, that's the type of reductionism, I think, right? And so I guess I would press you on is, do you really think the corporation could intend to do something if no one intended that? No human being had that intention in mind. I don't see how that can be the case.
Yeah, well, I don't think it could be the case if no one did. I think someone within the corporation would have to assert the proposition, let's do this. And then whatever mechanism or means within its standing plan that the corporate members have adopted to ratify or reject the proposition, if those criteria of validity are satisfied, it then doesn't matter that the resulting compromise, if you want to call it that, or the resulting resolution of the corporation, no one finds it completely satisfactory. The fact of agreement to the standing plan gives us all a reason to submit to the plan of the corporation once we've settled upon it.
I think that's right. I mean, so if the board of directors resolves and the thing passes 6-5 and an 11-person board, right? Yeah. The majority, the view of the majority of the board is the view of the corporation.
Yes.
Right. But that doesn't mean there's no entity there. It's not like the corporation is anything over and above the board and its members then. That's the extreme view, or I call it an extreme view. That's the extreme view I'm really worried about. One of my philosophical masters is Quine, and Quine has this great line about he loves desert landscapes and their parsimonious ontology, right? If I can eliminate an entity, I want to eliminate it, right? Which reminds me of a joke. You all know Occam's razor. Entities should not be posited beyond necessity. The great Sidney Morgenbesser at Columbia had what he called the weak version of Occam's razor. Entities should not be posited beyond possibility, right? If every group starts, generating its own entity, you could start asking really embarrassing questions about them, right? When I meet the couple, I meet the couple, their kid, and the wife, sings duets with the son. So I've now met 6 people: the husband, the wife, the couple, the family, and the duet. I think that goes too far. But I'll let Hadley ask the next question. We'll get somebody else.
Yeah. Well, one question I'd like to pose to Adam before on the argument about the case in Texas. I want to speak on how we understand it. Because you see, one of the poles here is that we've been very reluctant to have judges, secular authority, rendering judgments about the theologies that are valid or invalid within certain groups. But I gather you would have, if I read this correctly, you would have the authorities, the judge in Texas, just judge the question of which one of these groups comes closer to the original purpose of the group. Is that how it's done, or is it something else?
No. So I would say that what Robert called my moral thesis is actually much weaker than that. I would place this in the descriptive thesis. So I agree with Robert that the parties and the lawyers within the Diocese of Fort Worth should have perfect freedom to get it wrong. We should just let them get it wrong if they want. And if they get it wrong, well, then the judges should let the chips fall where they may. My descriptive thesis then is simply a distinction between the formal criteria that we use to evaluate the validity of a legal instrument and the ends for which people make those instruments, and to keep clear in our minds that those can come apart. When they're well formed, they won't come apart. Fortuitously, they didn't in this case. What judges should do when they do come apart seems to me a very, very different question. And I think there are very, very good reasons to insist that secular judges should not step in and look through the legal artifacts in those cases.
Just to be clear to our listeners out there and to me, how do you restate the grounds on which the judges in Texas decide this question?
Texas judges look at the the instruments constituting the Diocese of Fort Worth in light of the general rules of Texas Corporations Law and Texas Trust Law. And they say, you combine those two premises, the conclusion is the diocese is the true owner. And I think that's perfectly appropriate.
Okay. Let me just swing back. Thanks so much for that. Let me swing back to Rob, and we'll, again, some of these things we should do at the senior seminar. He makes me think of the old problem post-Shelley versus Kramer of whether somebody in a will can disinherit any one of his children who marries outside the race. We have a number of cases of that kind. So I was gathered that Rob was saying that, yeah, you could do whatever you want, but still there's apparently moral constraints, moral conditions that could be imposed even within the corporations and racist corporations. There was the old problem of the ship of Theseus. The timbers change, but we recognize the thing that's subsisting, the form. Same thing to the apolity. We've had generations die, but the main institutions that form the character of the place persist. And the enduring character is do you think, can the polity be obliged to honor its contracts? You make me think of that, a line I once tried and was exploded for me with Chisholm versus Georgia with John Jazar, where he said, well, if we say that under the Constitution, one state may sue another, what we're saying is that, what is a state? All the people who formed that polity, that community. So if we say that Pennsylvania can sue Delaware, we're saying all the people of Pennsylvania can sue all the people of Delaware. Then John Jay says, well, if that's the case, then one of those persons in Philadelphia must be able to sue the state of Delaware. Now, the counter to that is that, well, to say that the United States may declare war on Germany is not to say that any particular citizen of the United States may declare war on Germany. So I want to see, how far Rob presses. So I have those catches that come together. Is the human person something that can be deconstructed, or is that one of the irreducible points in your understanding? And can a state, a polity, a collectivity be held responsible then for its contracts, Rob?
So the way I'm taking the first question is, can a human being be reduced to other things the way I'm reducing trains to train cars? No, I don't think so.
Right. It's irreducible.
Right.
Okay. Right.
Now, there was an interesting question in the chat. Can the train cars be reduced to the wood and the iron and so on? Yeah, probably. Aquinas is quite explicit when he says that artifacts aren't substances. They're accidental wholes. So yeah, a train car really is just the substances of which it's composed, put together in some extremely complicated way. Okay. So yeah, probably train cars they're reducible too. Holding collectivities, responsible. Look, sure, but I mean, when a corporation enters a contract or a state enters a contract, right? What we're really saying, right, is that we're changing the relations between the outside contracting party and those human beings inside the entity, right, in certain complex ways, right? The creditor gets a first claim on the corporate assets ahead of the residual claim of the equity holders, right? A much more interesting question is, should you go around holding corporations or other entities criminally liable for their acts, right? It going without saying that you hold the individual human beings involved criminally liable for their acts, but do you hold the corporation liable too? My view is that that's probably a foolish thing to do. And there are plenty of people in corporate law who agree with me, and there are plenty of people in corporate law who disagree with me. But my view is usually if you get better deterrence if you just throw the book at the individual human beings, and when you hold the corporation itself criminally liable, what you do is impose costs on a bunch of innocent human beings. But there are arguments for both ways, doing it both ways, I think.
Right. I suspect it's another one of those cases we may be in heated disagreement. But the heated agreement, rather.
Darn it! I thought you were going to finally admit that you disagreed with me about something.
Oh, that's inescapable. That is escapable. I was going to say, Rob's function here is to make sure in the project that I get away with nothing. I couldn't even give a weather report.
So
But
Hadley,
but
this is
it seems, one final word, it seems to me that the good thing here is that it seems to me the premises of natural law seem to pervade this thing. It seems to be a large portion of what Adams has offered is happily preserved, but we'll go at this again. Let's open it up to the questions, Chip Garrett.
Yeah, we have a good
We'll
number
start
of
with
them.
Tom.
We have a good number of them in the queue.
Yeah.
So the first question was actually articulated by two of our friends, but in two slightly different ways. So 2015 James Wilson Fellow Josh Turner and Jordan Ballar of the CRCD both had questions that touched on that question of whether it's possible to reduce everything. And this is now me paraphrasing Jordan, all the way down to their constituent atoms and subatomic particles. And so Jordan wonders, by what principle do you determine when reduction is acceptable or necessary, or when it becomes improperly reductionistic? And Josh Turner asks the related question of why isn't atomism a legitimate view of man or human beings? So I think this was more to Robert Miller, but Adam, feel free to jump in too.
So you reduce, the question is really, can you reduce? You can reduce talk about F's. If you can reduce talk about F's to G's. If any sentence involving the word F, right, you can give another sentence involving only G's, and the sentences involving G's completely determine the truth value of the sentences involving F's. If you do that, you can get rid of F's in favor of G's. Okay? It often turns out that in situations like that, you can get rid of F's in favor of G's and G's in favor of F's. There are lots of situations in mathematics where, you can have sets or you can have categories, and you can mimic sets and categories or categories and sets. Which one's primitive? This doesn't answer that question. Okay? Why can't you get rid of human beings in favor of atoms? I think because you can't give any set of sentences about atoms that say about human beings everything you can say about human beings. There is no set of sentences which refer only to atoms which will entail the truth value of I believe in God. Robert Miller believes in God, or Robert Miller intends to go to the movies next Thursday. Okay? If that could be done, then human beings would be purely material things, right? And we could be reduced to atoms. I just don't think it can be done. And certainly no one has ever seriously attempted to do it, though there are people in neuroscience who are working on it. I predict they'll fail. Okay? There are actually even in quantum mechanics for thinking that it's called observers that under von Neumann's paradox can't really be material things. So actually
Lost it.
reasons in quantum mechanics for thinking it won't work. But I think it's going to work. I think it'll work. That cover both the questions?
So unfortunately, your feed was cutting out a little bit towards the end. But Adam, do you feel like you have enough to offer a response?
Just very, very briefly. Yeah, so Aquinas makes it very clear that artifacts are accidental in a way that human beings are not. But I take it that he means accidental in the Aristotelian sense, which is not, or that is contingent. Obviously, they're contingent on human agency, but human beings are contingent on God's agency. So I think the analog still holds. And the laws are artifacts. I'll just add that.
Great. Professor Jim Stoner asks, what are the implications of Adam McLeod's account of the natural rights of corporations for constitutional interpretation regarding freedom of speech in Citizens United and free exercise of religion in Hobby Lobby? Didn't the Supreme Court say corporations derive their constitutional rights from the individuals or natural persons who compose the corporation? Were they wrong to do so?
Yes and yes. So, I mean, I do think that's the approach the Supreme Court's taken, and I think it's wrong. I mean, I think this explains why the Supreme Court has really struggled with all of these cases, whether it's Little Sisters of the Poor, Hobby Lobby. You look at these cases where you have not a publicly traded corporation, but a closely held corporation, a family business, maybe even a large family business like Hobby Lobby, whose corporate identity actually is formed in large part by the interlocking intentions of its members. And then an employee goes to work for, say, Catholic Charities or the Little Sisters of St. Joseph of Boston, and is shocked to discover that they're Catholic, or goes to work for Hobby Lobby and decides that this evangelical owned business shouldn't be treated as an expression of the conscience of its evangelical owners. That seems to me just a mistake. It's a mistake that the court has bought into, that I think Maitland and Figgis and Dicey and the others would have avoided. I don't think that those earlier English jurists, in fact, it's very clear that they would not have insisted that a right and duty bearing unit is the same as a natural person. Maitland seems to suggest it's sort of somewhere in between a pure legal fiction and a natural person. But for purposes of the law, I do think it matters not just for pragmatic reasons, but for questions of justice, that we understand these right and duty bearing units as their own things.
Robert?
I guess I would just say one thing about close corporations, which is that while Adams was clearly much more powerful there than in the public company view, even with close corporations, you often get, some members of the family work for the business and then they collect salaries, but others don't. And they're of different ages. And, some people join the business because, it's like the best job they can get. And other people join the business because dad pressured them into it, right? And these things are frankly very unstable. They tend to, devolve very quickly when people die, because no one wants, if one brother dies, no one wants his wife to take over his job. The outsider, even if it's a relative by marriage, they might not know about the business. They've spent their career doing something else. They're not any good at the business. They don't want to work for the business. What you often see in exactly these types of family businesses are provisions that say, if so-and-so dies or if so-and-so wants out, we'll basically wind up the business. We'll sell it, and then we'll divide the money in cash. There's the point in the paper, I think, where Adam says, there's a group of people, someone can leave, other people can join, the group persists. Sometimes, not always, right? Small businesses, they don't let outsiders in. They take steps to make sure that doesn't happen. You can't just freely transfer your shares. You've agreed not to. Under common law of partnership and under the Uniform Partnership Act, if one partner leaves, the partnership dissolves. It doesn't continue, right? The remaining partners can reform it. They can admit a new partner and so on, but it dissolves automatically on a withdrawal of a partner. And that's kind of the rule you usually get in like these family LLCs. There are very strict rules about how you get out, what happens when people get out, for winding up the businesses, people getting their money out. They're unstable, and they're inherently unstable because people, no one goes into the family widget business because they love widgets. Okay, they go to the family widget business because they want to make money selling widgets, and they're or other reasons, or the dad pressured me to be a widget guy. And they tend to be very unstable. They don't last very long. The ones that last a long time are the exceptional ones, I think. Sorry, but I'll stop talking, let you go back to a question.
Yeah, so right now the queue is open. I guess I just had one question. I remember in the Hobby Lobby decision by Justice Alito, he noted that the Little Sisters of the Poor were making we're materially cooperating with an evil. And so I guess my question for Adam is, like, what level of attenuation between a company saying, sorry, what level of attenuation do you think is possible between a company saying that its constituent, employees or members are materially cooperating with an evil versus the company itself, being complicit in a material cooperation with an evil? Or do you see no distinction there?
Well, there has to be a distinction because definitionally material cooperation is a continuum, right? That's what makes it different from formal cooperation. So I'm not a Catholic theologian. I can't say when material cooperation becomes sufficiently material that it implicates conscience. I will say this, though. It's awfully hard to comprehend the claim of the Little Sisters that the Little Sisters of the poor have, that the conscience of the Little Sisters of the poor, qua Little Sisters, is implicated in this material cooperation. Insofar as none of the individual Little Sisters is signing that form which authorizes the payment of health insurance benefits for contraceptives in her individual capacity. Any of them who signs the form is doing so as an agent of what? The corporation, the group, the association. And again, I think this is a big confusion in the court's jurisprudence. It's an inability to see that the individual consciences of the members could be formed by the intentions and plans and commitments of the group. And that group can be, the group's conscience and intentions can be formed by the conscience and intentions of a larger group, call it the Roman Catholic Church. So it is the case that there are group agents which do influence the moral and legal commitments of their individual members, insofar as their own agency and capacity to bear rights and duties is a separate and distinct thing from the individual members. And this is how we can understand individual members who find themselves out of compliance with the group's purposes and intentions, or in contravention of.
Thank you. Thank you. That's helpful. Well, Hadley, we've put out the siren the beacon for more questions.
You have a question in the queue. There's a question in the queue, Garrett.
Is there a question in the queue?
Yeah.
Oh, yes, we do have another one. Thank you, Robert. So this is from actually another one. We have two more. So from Andy Olry. So he asks, how would Professor McLeod determine when a new entity with its own identity has first formed? What are the necessary elements? I.e., in the two runners example, at what point have we turned the corner so that the two are no longer just runners who occasionally pass each other and talk, such that a new natural entity with its own identity has formed? Oh, you're muted. Yeah.
Sorry. So there are a couple of thresholds. If I understand Bratman's theory correctly, Robert thinks I don't. The first threshold is the moment you have two people with an interlocking intention. And all that means is we share an intention each because the other one does. So the simplest case of this is a friendship. I want your good. This is Aristotle's account of the central friendship. I want your good because it's good for you, because that's good for me, because I want your good. So there's a mutuality here to our shared good. But the second threshold is once the group becomes big enough, the group has to form what's called a standing plan, which is something that's different from my particular intention or your particular intention to show up in any particular morning. When there's only two of us, we might send a text message, hey, I'm really tired tonight, let's not run tomorrow. But at some point when the group becomes big enough, the group is going to get together and run because it has a standing plan to run every Tuesday, Thursday mornings. And individual members might not join, but the running group is still understood, intelligible to us as an artifact of the individual members that exists separate and apart from the identity of those individual members, insofar as the group is going to run on Tuesday and Thursday mornings. So those are a couple of different thresholds. There is a continuum here, right? We have to acknowledge artifacts are not natural persons, and corporations are closely held, or they're instrumental. I disagree with Robert that no one goes into the family business to make widgets. I think there are lots of people who take on the family farm because they identify as farmers, right? So he set me up for that. But I do think it's the case that there are spectrums and continua here, But I do think that there's some reality within the artifact that we have to grapple with, not just as a matter of pragmatism, but as a matter of justice.
I want to concede that Adam's right. It's like so foreign to my mental state. But yes, there are some people who absolutely go into the business for the sake of making widgets. But there are a lot of people who go into the family business because they think it's the way to make the most money of the various options open to them too.
Yeah, it sounds like.
Great. We have another question from Professor Jeff Tuamala. He asks to Professor McLeod, is Aristotle's view of the state compatible with your natural law assertion that we flourish in small communities?
Wow, that's a big question. I don't know, but I will say this. So I follow the natural law philosopher John Finnis in thinking that Aquinas actually has the better view of the political common good than Aristotle, insofar as Aristotle thinks that the political common good is comprehensive, and Aquinas thinks that the common good of the local, the smallest community, particularly the family, whose common good is comprehensive, is primary, and the common good of the state or the political community is subsidiary. And that seems to me exactly right. It seems to me that insofar as the state shares a common good, it is a mere instrumental common good. That the good of the state or the political community as a whole is simply to secure the preconditions so that those smaller groups who do have true basic common goods to them, like the family and the church and the university and the small family business, can flourish. I think this is a way in which publicly traded corporations resemble states. And I think it bears upon many of our controversies today about whether, to what extent we ought to treat transnational corporations like, Facebook or other big tech companies, to what extent we can analogize their powers to govern, say, speech to the powers of states. These massive transnational publicly traded corporations really don't have a basic common good to them at all. It's almost purely instrumental. And that does make them quite different from the family business or the church.
Good.
That's kind of interesting because under Delaware law, the board of directors of a Delaware corporation has an obligation to act to maximize value for the shareholders, to make as much money as they can within the law. You're not allowed to do anything illegal. If you intentionally do something illegal, you're personally liable for it as director. Right? So within the law, you're supposed to maximize value. So in a certain sense, they have a purpose, right? But it's super general. I mean, you can make money in any zillions of ways, right? So it's not. If you're Apple, you don't have to make iPhones. If it turns out you're better off selling the iPhones than investing in corn futures, go ahead, right? That's what you're supposed to do. What I think makes them interesting problems for today is not that they're public companies. There are a lot of public companies. We're not worried about REITs that own college dorms throughout the United States. We're not worried about them as a threat to democracy. And it's not even that they're big. There have been corporations that have been really big for a long time. People who hate ExxonMobil think it's a state danger to the climate, not to democracy. Okay. What makes the tech companies interesting is that they control the flow of information, and the interesting thing about that is that they have so much control over the flow of information that their power, at least according to some people, and there's something to this, rivals that of a government. So what you should probably do with them, if they actually have a monopoly power on a certain information market, is treat them the way you treat other people who have natural monopolies. So for example, it's a natural monopoly to provide, natural gas service to your house. It's a natural monopoly to provide electricity service because it's just not worth it to string two sets of electricity wires or have two competing sets of gas pipes from two competing gas companies. So when we have natural monopolies, what we do is the government comes in and it says, okay, we're going to regulate the rates you can charge, and you have to provide gas service to anybody who asks on the same terms as everybody else. You become a common carrier. So, does it make sense to, treat Facebook or Twitter and so on as a common carrier and say they have to take everybody on equal terms? Maybe, and don't let them viewpoint discriminate. Possibly. Richard Epstein's written about stuff like this.
Yeah, Richard's very good. I'd say that, if you look at if you ask the question, what constitutes the essence of a state, you're going to see more or less different aspects of that essence show up in, say, a large transnational corporation that has a monopoly position. Ultimately, they lack coercion. So, to the extent that coercion is fundamentally what constitutes a state, we're going to distinguish them for that purpose. But they could be similar in other respects that are in their core identity. I think
Amazon's real powerful, but Amazon could be taken down by one company of Marines in the course of a busy afternoon.
Yeah, right.
What company? Right. What was that?
One company of Marines in a busy afternoon.
Yeah, it's like
Oh, go ahead, Hadley.
No, it's the image of the Marines coming in to remove Sewell Avery from his chair at Montgomery Ward's, the long arm of FDR. Quickly for Adam, though, we have this argument about the common good in our law, and I take it there's no policy out there that will affect everyone materially in the same way. So we know that, right? So the question is, how is the common good manifested in the polity as a whole? And I guess one answer would be that we're working on the procedures that we think are intrinsically intrinsically true. And to the extent that we're governed by things that are rightful, we can say, okay, that is a common good. Would you take another angle on it, Adam?
Yeah, I do think it's more the procedure. So it seems to me that if we're going to define the the common good of the political community, it would have to, at the very least, include two things: defense of the homeland, and provision for remedying rights, deprivation of rights. I think it was maybe John Goldberg who wrote an excellent article in the Texas Law Review a few years ago, arguing that there's a fundamental constitutional right to go to court and have your torts redressed. I find that perfectly plausible.
I don't think it's silly process. I think there are substantive rules such as anyone accused of a crime should have access to the witnesses and evidence against it. So as you build a society with those kinds of rules, you say, well, even though things may go wrong, judges may be corrupted, juries may get it wrong, still there's any regime that calls itself the rule of law should have these kinds of features.
Yes.
All right.
Yep. Let me freak Hadley out a little bit. You know what I think is really important in the common good, Hadley? I think what's really important in the common good is not, for example, things necessary for human flourishing. Food is necessary for human flourishing. I don't want the government running the damn restaurants.
I agree with you.
They all look like government cafeterias.
I agree with you.
What the government should do is provide what economists call public goods. Those important things like Adam mentions defense, but also courts and roads and so on, that the market will not provide because the transactions costs are too high. All right, there are some goods where the transactions costs are best addressed in the market. There are other goods that are where the transactions costs are best addressed by government. It's those latter things that government should do, the place where it has a real advantage over the market.
I'm wholly in accord. That fills out the scheme of what anybody could mean by the common good. There's just one other thing, point that Robert reminded me of. I recall a scene years ago at an alumni gathering where a late colleague of mine, Tom Yost, is an old communist. The room was filled, and he said, folks, the people think this human being is a moral agent. He looked up at me and he said, no, it's really a bunch of aqueous protein, Hadley. Just a bunch of aqueous protein. I remember saying something like, well, Tom, it could be, but at one point, one of those collections of aqueous protein dropped out of the tree and started conjugating verbs. And the other one went into the field to organize for Henry Wallace. And then you see that some people say, well, all we mean is the right of beings who can give and understand reasons to be ruled with the giving of reasons. And now we may have computers that can play chess and actually give plausible reasons. So I say, if we try to reduce things like that, a forked creature who conjugates verbs, a creature who can churn out reasons almost robotically, I think that would not satisfy your sense of what the human person is. It forms a key ingredient.
No, definitely not.
Right.
Right. I mean, it's sort of the famous, Searle's Chinese box argument, where
Right.
you have a guy in a box with a really complicated manual that you send in a piece of paper with something in Chinese written on it, and he looks it up and he follows a whole bunch of complicated rules, and he writes down, so he copies out some Chinese characters and sends it back. And if you sit on the other side, it looks, it kind of looks like the box is having a conversation with you, but there's no mind there.
Absolutely.
The mind of the guy who could be replaced with a computer is not a real mind.
Absolutely. Okay. Okay, Garrett, where are we? Think it's time to close down things? Thank everybody.
Yeah, I
Garrett?
think so. On behalf of all of us at the James Wilson Institute and the First Liberty Institute's Center on Religion, Culture, and Democracy, we'd like to thank all of you for attending today's webinar. In particular, we'd like to thank our two presenters, Adam McLeod and Robert Miller, for their generous time and their presentations. This was a real treat. For all of our attendees, this webinar will be available on YouTube, and we'll follow up with an email so that you can share it with your friends. And we encourage you to follow our work at the James Wilson Institute and on the Center for Religion, Culture, and Democracy. We will be doing more webinars, and so we look forward to seeing you again. So thank you, everyone.
Yeah, thanks to all those people who signed on and stayed, carved out time of their own to be with us. So, as Tiny Tim says, God bless us, one and all.